Okay, I suggest we kick things off. I'd like to warmly welcome everyone to the second webinar in our Teaching International Law series. Welcome back to those of you who attended our morning webinar, and welcome for those who are newly joining us for this webinar. My name is Barry Sander. I'm an assistant professor at Leiden University, and I'm one of the co-conveners of this series. I'm going to pass you to the other co-convener, Jean-Pierre, who's going to take you through a few logistics and introduce the webinar. Thank you.
Thank you, Barry, and welcome back, everybody. For those people who have just joined us, I'll just run through a couple of logistical points. Main one being that there is a Q&A function. So if you have questions, please do feel free to write those in as we go. The sooner you write the questions in, the more opportunities people will have to upvote them, as well as for the speakers to be able to think about the answers before they get asked the questions. The second point, which is related, is that there is the possibility of upvoting questions that you are interested in. So if there's a question that you particularly like or that you would particularly like answers to, please feel free to upvote it so that we make sure that we address it in the course of this webinar. The third point I wanted to mention is that we might not have time for all the questions received. However, rest assured that all the panelists will receive the questions and they'll be able to think about them afterwards, and we encourage you to continue the conversation offline as well. The other thing I wanted to mention is that if we encourage you to tweet about the discussion using the hashtag teachingIL, as well as the BICL Twitter handle, which is @BICL. So that's it from the logistical end. From my end, it's my great pleasure to welcome Anthony Engi, who will be chairing today's panel. Tony needs no introduction for most of us. However, I'll give one anyway. Tony is a professor at the College of Law at the University of Utah. He holds a BA and LLB from Monash University and then his JD from Harvard. And his work covers both public and private international law, with particular work on human rights, globalization and use of force, as well as colonialization and the history of international law and third world approaches to international law. Anthony, over to you.
Okay, so welcome everybody, and let me again thank Barry and Jean-Pierre for organizing this wonderful series of webinars on teaching. I should say at the outset that unfortunately we will be missing two of the advertised panelists. Unfortunately, Imogen and Chinmaya will not be with us. And this will, I guess, affect the program. But I thought what I might do at the invitation of Barry and Jean-Pierre, given that we do have a little extra time, is to talk about something that Barry mentioned in the initial very interesting webinar. And that is about the issue of how legal sustained study has been done about the teaching of international law. And we hope that this webinar will remedy that. Just in terms of Asia and international law, I thought I would try and give a background of one possible history of this whole question of teaching international law in Asia. So it's very interesting to note, and here really I'm taking the opportunity to provide an extended blurb about a program I'm associated with called TRILA. It is called Teaching and Researching International Law in Asia. But I hope this is not too much of a departure from the advertised, you could say, event, because it is about the teaching of international law in Asia. And what I found very interesting was that, in fact, there's a history of inquiry into this specific question. So if I can share screen, just to give a sense of some of the discoveries I made when organizing a particular conference. There was, in fact, in 1964, a roundtable held at the University of Singapore called the Roundtable on the Teaching of International Law and Relations in 1964. And quite a remarkable group of people attended this particular meeting, including Miles McDougall, L.C. Green, B.S. Murthy, Judge, later to be Judge Feliciano, Professor Nadaraja from Sri Lanka, Sompong Sucharitskul from Thailand, and various other very eminent international lawyers. Boutros Ghali also attended this particular event. And I just wanted to read from you one of the passages about the reason for this event, or one of the questions that should be looked into at this event. And I quote from the 1964 report. The question is whether international law, as it has been known to date, is in fact of limited usefulness due to its Western origins, and whether there are special problems peculiar to the new countries, especially of those in South and Southeast Asia, which require revision or adjustment of international law principles. It's interesting to note that terminology, the new countries of South and Southeast Asia. So this was adopting the language, I suppose, of the time when these very ancient states were presented as new states because they had been recently decolonized. I should also mention that in Singapore in 2001, there was yet another conference on the teaching of international law in Asia, and this was organized by my colleague Kevin Tan at NUS. And that produced a whole series of essays by various international lawyers, including Professor Saunaraja and Lian Theo, about the teaching of international law in 2001. Surya Subedi was there, Raul Panga was there. And so that's an interesting body of literature to have a look at. Another source I might mention here is Professor Onuma Yasuaki. And in 1981, Professor Onuma attended the American Society of International Law, and he wrote on the Eurocentricity in the teaching of international law. This is in the 1981 proceedings of the American Society of International Law. So this is simply to say that these questions about how to teach international law, how to deal with Eurocentrism, whether a different type of international law is needed, are questions that have been a part of the thinking of many Asian teachers, stretching back many decades. We held a conference in Singapore in 2018, the TRILA conference. And the basic purpose of the conference was to get some sense from participants all over Asia, and not just in Asia, but also participants from Africa and Latin America and Europe, and from the United States as well, about these issues about teaching in international law. My thinking basically was that we needed to get a global conversation going. And my hope was also that rather than focus just on Asia, that we would see the connections between the issues facing international law teachers in Asia, as well as international law teachers in Africa and Latin America. And these were some of the core issues that we explored. Materials to be used for the teaching of international law, well, you can read it. The creation of a syllabus, course outline in international law, effective teaching techniques, challenges in researching, writing, and publishing. We were very conscious of the fact we made a point of inviting younger scholars to this conference because, of course, they are the people who are planning their careers, and in many ways, the people who are facing specific challenges in this world of what I would call neoliberal international education. And just to say that we produced a project report in 2020, and this is available on our website. And if you're interested, you might have a look at that report, which consists both of particular topics being covered by the participants about the teaching of international law, their experiences, and also a fairly comprehensive survey that we took, asking people to respond about the conditions in which they teach, the textbooks they use, and so forth. And then as a result of that, following from that, we've developed a program that we call TRILA on the Road. And the basic idea is to hold seminars in different countries, focusing on issues that are defined by people from those countries who say, well, we'd like to have a session about the history of international law, or a session about teaching techniques, or a session about tips about publication, how to go about the process of writing and researching for publication. And so we've held a number of conferences in various countries in that regard. Okay, so I just wanted to give a sort of introduction to some of the things that we have been doing as part of the program, and also to suggest this connection with sort of history of inquiry into this whole question of the teaching of international law in Asia. So I just wanted to say that by way of introduction. And having said that, I think we can now, if I could ask you, Jenny, to please give your presentation. So Jenny has a very interesting presentation based on her experiences in the Philippines and Myanmar. And Jenny is a graduate of Harvard Law School and has also worked in Myanmar and, of course, in the Philippines. So Jenny, if I could hand it over to you.
Thank you, Professor Alji. I will share my screen. I prepared the presentation for today. Can you? Can you see it? Is it good?
Yes, we can see it.
Okay. First of all, I'd like to thank the British Institute of International and Comparative Law for giving me this opportunity to participate in the webinar. Good evening to everyone based in Asia, and good afternoon to everyone based elsewhere. Um, I am speaking here in my personal capacity, and whatever views that I share here are my personal views and do not reflect the views of my organization or my colleagues. So, this topic, teaching international law, appealed to me back in April when I saw the call for papers, even if I wasn't teaching international law in an academic setting. And as I've already mentioned, and as the professor mentioned, I work as a lawyer for an NGO. And I often read about the need to decolonize international law. And I can say, as a human rights lawyer from the Global South and working in the Global South, I find it an extremely important project. Um, even if I, even if the work that I do is really supporting the mainstream public international law. Decolonizing is often discussed in the classroom context where a professor decolonizes the law curriculum. But in my view, for this project to succeed, we must also look at how a country's legal culture and professional culture affect the opportunities for decolonization. So my presentation, my presentation is all about asking this question. How does one learn international law? Or how does a lawyer learn international law in her country? And in my view, the answer to this question shapes the spread and ownership of international legal doctrine and the development of international legal doctrine in a given place. I will illustrate the points that I'm going to make by using examples from two countries that I've worked in, Myanmar and the Philippines. Um, Notably, these two countries in Southeast Asia have pending proceedings at the International Criminal Court. My reflection draws from various experiences. Here in Myanmar, I previously taught human rights and international criminal law to human rights defenders in a workshop and through a short course in 2019. Currently, in my capacity as a legal advisor for an NGO, I provide briefings on the international proceedings affecting Myanmar to various stakeholders and even to the public. In the Philippines, I wrote about ICC processes in newspaper op-eds and media interviews in 2017 and 2018. Why am I saying all this. It bears on my point, which I will later on discuss, about alternative spaces where people encounter international law. What is interesting in these two experiences I've had was that I was explaining legal concepts such as complementarity and justice and accountability uh, in a very polarized political climate. But across the political spectrum, there was a public clamor to know what these things mean and what these things might mean for their country. So, with that, I'll start with Myanmar. So, many of you may already be familiar with the various international proceedings concerning Myanmar. This was triggered by what happened in 2017 in Rakhine State, which is the home of the Rohingya ethnic group. In 2017, the military conducted clearance operations in Rakhine State, which drove hundreds of thousands of Rohingya to flee Myanmar for Bangladesh. This was the last straw, but the persecution of the Rohingyas has been going on for decades. In 2019, and I think even in the same month and maybe even the same week in November, in 2019, various legal pathways opened up internationally for justice and accountability for the Rohingya ethnic group. So what you see here in front of you are four of these mechanisms concerning Myanmar. The first of these is the ICJ case between the Gambia and Myanmar. So in November 2019, the Gambia filed an application before the ICJ alleging that Myanmar violated its obligations under the Genocide Convention. So Myanmar has been a party to the Genocide Convention since 1956. And later on, I will talk more about this. The next one, let me just describe very briefly. The ICC, in November 2019, I think the pretrial chamber authorized the investigation of possible crimes against humanity committed partly in the territory of Bangladesh, which is a state party to the Rome Statute. And as I said, in the same week, the Burmese Rohingya organization in the UK filed a criminal complaint in the Argentina courts under their universal jurisdiction law, alleging the commission of crimes against humanity. And this complaint in particular was leveled against both military leaders and civilian leaders. So the state councillor was also mentioned in the complaint. And quite differently from the three preceding mechanisms, this last one, the Independent Investigative Mechanism for Myanmar, is a UN body that was set up by a Human Rights Council resolution in September 2018. Some of you may know or have heard about the UN fact-finding mission on Myanmar, which produced a comprehensive report in 2018 recommending investigation for possible international crimes committed in various parts of Myanmar, not just in Rakhine State and not just pertaining to the Rohingya. The IIMM continues the work of the FFM by collecting, consolidating, preserving, and analyzing evidence of international crimes that have been committed in various parts of the country and which may be used in various criminal proceedings, not just international criminal proceedings before the ICC. So it could be a national court or a regional court, although there's no regional court in Asia. The picture that you see in front of you was taken in December 2019 during the ICJ hearings for the provisional measure request filed by the Gambia. I took that photo. This photo was taken in Mahabandula Park in downtown Yangon. And this is a live stream of the hearings. And as you can see from the picture, ordinary individuals are watching the proceedings, which I found very surreal because usually we know of international law as something that is studied only by lawyers and by a very a small group of people in a country, and these proceedings that are witnessed by ordinary people is for me remarkable. Now, when these proceedings were taking place in December 2019, the state councilor faced a lot of international criticism um, for representing Myanmar at the World Court. Um, they were saying how this democracy icon fell from grace, and is now denying accusations of genocide. Um, but a different story was unfolding within the country. As as the hearing, I think on the day of the hearing, there were rallies in support of the state councilor. Crowds gathered in the streets of Yangon and in the capital, Naypyidaw, cheering their beloved leader for defending the country against Western bias. Billboards with the message, "We stand with you, Daosu," lined highways and major thoroughfares. As proceedings before the World Court were taking place, the international and domestic reaction could not have been more polarized. And I should say here that even within the country, reaction was also divided among the public. Now, not further in time and place, in March 2019, the Philippines' withdrawal from the Rome Statute took effect. Um, as you may know, the Philippines became a party to the Rome Statute in 2011. The state withdrew from the treaty on March 17, 2018, because of certain events. In 2016, the Philippines elected a new president, Rodrigo Duterte, and he launched a campaign against illegal drugs that was implemented by the Philippine National Police. Rights groups and even the country's national human rights institution uh, have documented how thousands of individuals have been killed in the context of the war on drugs. And in early 2018, the ICC prosecutor announced that it would conduct a preliminary examination in the situation in the Philippines. And shortly thereafter, um, the government withdrew from the treaty on March 17. Now, what is striking here, if you look at the notification that was sent by the Philippine government to the UN Secretary General, was the language that was used in justifying the treaty withdrawal. So I'm quoting here. Um, yes, so the government justified the decision to withdraw as and I quote, "a principled stand against those who politicize and weaponize human rights, even as the country's independent and well-functioning organs continue to exercise jurisdiction over complaints," and I end quote, regarding the war on drugs. Now, at this point, you may be wondering, what does all this have to do with international law teaching? And I think, just based on my work in these two countries, with respect to these very sensitive issues, I realized, based on my practice, is that it's not enough to enact laws and ratify treaties, which is something quantifiable that NGOs tend to focus on or fixate on. What is equally important is the legal professional culture, and how that is as important in disseminating legal doctrine and ownership over international law. And in and just going back to my main question earlier on, how does one learn international law? And based on my work in these two countries, law school is not the only place for learning international law. In fact, in the Philippines, international criminal law, even if the Philippines was a party to the treaty in the 7 or 8 years from 2011 to 18, 7 years, 19, so 8 years, ICL was not generally taught in law schools, because even in the state university where I studied and where I now teach, University of the Philippines. So the priority is really for bar subjects. And because of the priority, maybe just a bit of background, we follow the American system of legal education where law school is a graduate school, a Juris Doctor, and then you take a bar exam, which is a qualifying exam, and then you can practice law. Anyway, law schools, their priority is to produce graduates who can pass the bar exam. And what does this mean for public teaching international law? Only uh, mainstream international law is the priority because that's what gets tested in the exam. Um, and so there is very limited space for other subfields, and also for a decolonized version of international law. Um, with respect to Myanmar, that the legal professional looking at the legal professional culture will require considering how military rule for decades undermined the rule of law, and in turn that has undermined the legal profession. So there's not a high regard for lawyers in a country where there was no need for lawyers, decades where there was no need for lawyers. So um, I'm not saying that these two instances are the main factor, but I think based on my work in these two countries, they are a factor. So, what are these alternative spaces for teaching and learning international law? As I mentioned, one is in the NGO workshops and in the public briefings or private briefings to stakeholders that NGOs conduct. You can also write in a newspaper. But as I'll later say, both of these spaces also have limitations, and I'll talk about that in the next slide. How do you teach international law given this space and given that your audience are not necessarily law students? Um, First is that I think you need to engage national narratives. So in the Philippines, this means connecting international law to issues that are important to many Filipinos. And for example, that is the South China Sea issue. And in fact, in 2019, a handful of legal luminaries in the Philippines submitted a communication to the ICC prosecutor to look into possible crimes against humanity that was committed by China in the South China Sea. So, and the ICC prosecutor, I think, decided that the EEZ is not within the territory for purposes of exercising territorial jurisdiction. That's not what I'm trying to get at here. Instead, what I want to point out is that the connection that was made by a handful of Filipino lawyers between international criminal justice and um, the law of the sea. So connecting these two seemingly disparate fields. And in Myanmar, what I often encounter when I conduct these workshops and these briefings is the connection of these talk of accountability with the military state. And uh, I borrow the term of Melissa Crouch, a legal scholar who has studied the Constitution of Myanmar. Um, and basically, for Crouch and for many people in the country, the 2008 Constitution of Myanmar still protects the military. And one concrete example of this is how 25% of parliamentary seats are automatically reserved to the military. And important amendments to the Constitution cannot be made without, I think, 75%. So that control is very important for purposes of democratic transition. And then also another connection or another question that is commonly asked when I conduct these workshops is, you know, to poverty and inequality, so economic development of Myanmar, given that for many decades it was closed off from the world. And lastly, I think this is very important and crucial for international accountability is the way that British colonialism affected the human rights situation in the country, especially with respect to the Rohingya. There's a lot of debates about that, and people who don't support human rights actually use the narrative of colonialism to justify how proceedings are an indication, international proceedings are an indication of Western bias. So I think for people, um, for lawyers like myself, I think it's important to engage this narrative, if only to correct any inconsistency and to admit where international law fails. And so, for example, whenever when I get asked the question, how come the ICC is only looking at Rakhine State? Why is it not looking at Shan State or other Shan State or Kachin State where there are basically conflict areas? And I tell them, oh, because of the territorial jurisdiction, blah, blah, blah. And I admit that it is not a perfect system with it has its own limitations. And I think the value there is for them to know all of that and to decide whether to support these institutions. This is my last slide. And these are some of the things that I've learned based on teaching international law in this way, through the workshop or by writing about it or by conducting briefings to various stakeholders. First is there's a limited space for discussion. If you write in a newspaper column, it's obviously one way. There's very limited opportunity for feedback or a response or reaction. If you conduct a workshop or a short course or a briefing, the duration is very brief. Academic freedom is also not available, and you need to conduct these sessions closed door most of the time, to make sure that you are not exposing yourself to physical risk. And I should say here, actually, it's interesting that in one of the public briefings that we conducted, this was back in January 2020, it was the public briefing was organized by the embassy here in Yangon. But what's interesting is that the date coincided with the release of the order, the International Court of Justice order for provisional measures. And so you have to be careful as well in the language that you employ, even as you try to be accessible, even as you try to make these legal concepts accessible to the public. And another important point that I'd like to share is that because of these alternative spaces, lawyers are not necessarily engaged, and therefore you have many lawyers who may know a lot about domestic law but not about international law. But the upside is that you also have a lot of non-lawyers who can access the writing or the workshop. And I think this is my last point. I'd like to connect this to the broader context of international legal practice. So we know that there are very limited options to become an international lawyer if you don't come from certain countries. And I think this also goes both ways. So we've often suggested improvements on how these international institutions can be more diverse and more representative of the world. I think one other way that we can strengthen a more representative international institution is by changing the legal culture in a given country. So, for example, in the Philippines, if your priority is simply to produce students who can qualify to be who can qualify as lawyers and pass the bar exam, then there is definitely no priority to look for funding sources for students to do unpaid internships in international courts, right? And there is very little incentive for universities to participate in the very in ICJ clerkships, for example. But this also goes the other way. So the ICJ must also not limit the opportunities to elite institutions. And then there is the issue of language fluency. Excepting Philippines and some other Southeast Asian countries, some other Southeast Asian countries like Thailand, Myanmar, English is not their first language. And there's even as you, the language requirement to know English and French, in on paper it's or, but in reality it's and. So that would definitely close off opportunities for people here in these countries. And I think even if I don't have empirical research to back up my point, it's something that I feel, um, I I sense. It's something that I sense in my work in these two countries in the past few years, that if we change the conditions and the opportunities available for decolonizing international law and for expanding opportunities for students to become international lawyers, then I think international law will be more representative and of the world and more, yeah. So I'll stop there, and I welcome your questions during the forum. Thank you very much.
Thanks so much, Jenny, for such a wide-ranging presentation about all the different contexts in which the teaching of international law matters, because we shouldn't confine ourselves just to the classroom. And it's very dramatic to think about teaching international law in a context where a very important case is being considered at that very same time. So thanks very much for that. Our next speakers are Otto Spikers and Zhang Fan, who will be speaking about their experiences or about, well, I think this is relevant to everybody, because we've all been through this ordeal, I think, of teaching by Zoom in the time of the Corona crisis, the ongoing crisis. Just by way of background, Otto, I think has your academic training was in Leiden, and you're at Wuhan at the moment, and Zhang Fan, you're also teaching at Wuhan at the moment, a very prominent, eminent international law school in China. In fact, I think some very famous international lawyers have been produced at Wuhan, and I think it takes great pride in its work in international law. So we look forward to hearing from both of you. And I'm not quite sure how you've decided to divide up the time between the two of you, but I'll leave it to you to proceed. Thanks.
Yes, thank you very much, Professor Engi. Did we manage to show a PowerPoint presentation? I'm not sure. Oh yeah. Yes, there it is. So the way, just to answer the chair's question immediately, we will adopt the sandwich method. So I will begin and then turn it over to Chang Fan, and then I will close again. So that is how we have decided to divide the tasks. So our presentation is about online teaching in the time of Corona. Well, we are both situated at Wuhan University. I guess that is why we were put in the panel of teaching international law in Asia. But our presentation is not really about the peculiarities or challenges or anything that comes with teaching international law in China or Asia for that matter. It's more about challenges that come with teaching international law in times of Corona. And as the chair pointed out, that is something people are wrestling with all over the world. That's not particular to China or Asia. But of course, Wuhan, the place where we are now, is very much associated with this virus for whatever reason. Before the virus, nobody knew where Wuhan was, and now everybody knows. So we both work at the China Institute of Boundary and Ocean Studies at Wuhan University. And since 2015, we've been teaching a course together each year on the sustainable use of shared water resources. And my colleague, Chang Fan, begins to teach in Chinese, and then halfway through the course, I take over in English. And the main theme of our course is the sustainable utilization of transboundary freshwater resources. And we always end our course with a moot court exercise. In the beginning, we used a fictional case, but last couple of years, we've been using the Grand Ethiopian Renaissance Dam situated in Ethiopia as our case study. I will say a bit more about this mood exercise later. The title of our presentation, Online Teaching in the Time of Corona, is obviously stolen from or inspired by the novel Love in the Time of Cholera, which was published by Garcia Marquez, a famous Colombian author in 1985. It's a love story which takes place in a community that is heavily troubled by outbreaks of cholera. And the enduring love of the main characters for each other contrasts very nicely with the surrounding corporal decay in this novel. So in our story, if you want to make this comparison and pursue it a bit further, in our story, the love for each other is replaced with our love for teaching. And of course, cholera has been replaced with another virus, and that is corona. So let me just give a very brief outline of our presentation. So in a minute, Fan Zhang will continue, and she will first say something about the circumstances of Wuhan in the beginning of 2020, so of last year. And then she will make some remarks about the way the Chinese government and Wuhan University and our own institute in particular have decided to adapt the teaching methods to this new situation. And she will then share her personal experience teaching her part of the course from her apartment in Wuhan at the height of the lockdown. I will then take over and share my experience in preparing for my lectures and delivering them. I did so from my apartment in my hometown, The Hague, in the Netherlands, so situated far away from Wuhan. And I was basically unaware of the circumstances the students were in at the time I was teaching them. Just to avoid any misunderstanding, I am now currently in Wuhan, so I managed to travel to Wuhan in October, and I've been there in Wuhan since that time, and enjoying myself greatly, I may want to add. I will end our presentation with some remarks about the value of teaching in these difficult times. So I now give the floor to my colleague, Jan Van.
Can you see me?
We can see the slides.
Yes, yeah, you're fine.
Okay. Okay, thank you, Otto, and thank you, Professor Angie, and my dear colleagues. I feel greatly honored to be here to share with you my experience of teaching online in the time of coronavirus. As the epidemic is spreading around the world, teaching online is no longer unique experience to Wuhan or to China. But in last winter, when my city Wuhan was halted by the sudden heat of the coronavirus outbreak, to move courses online was a decision carried out in a rush, never prepared, and without example to follow. Wuhan got locked down on January 23rd during Chinese winter holiday. The decision to postpone the reopening of campus was made soon after that on January 31st. And it was from that day onwards that we were required by the university to explore ways to provide online courses. The policy of lockdown became stricter and stricter. On February the 11th, every apartment complex was also locked down, which added to the difficulty of finding supporting materials for online teaching. But Wuhan University still managed to offer online courses from February the 24th, in sync with the original schedule of the spring semester. The lockdown of the city was lifted on April the 8th. However, the campus was not reopened until May, and the face-to-face classes remained suspended until September. So in fact, all the classes of the spring semester were given online. During the lockdown, the Ministry of Education of China issued a policy called "Classes Suspended, but Teaching and Learning Continues." But how to continue teaching and learning? The ministry did not give a unified answer. Wuhan University did not make any specific requirement either. It simply required the teachers to get ready to conduct live lectures and guide students' independent study, to take the initiative to contact with students and make full use of QQ groups and WeChat groups to answer questions and solve problems online. And the teachers were given the discretion to decide whether to assign homework or to give assessment. Most of the teachers in the university had no prior experience in online teaching before the pandemic. But at that time, with the expectation that the pandemic would not stop quickly, teaching online became the only way to ensure the completion of the teaching plan and to reduce the impact of the pandemic on the students' learning progress. CBOS organized the discussions on specific form of online courses. There were three main focuses in the discussion. One was whether the main form of online course should be to provide lectures or to guide students' independent studies. Some of my colleagues suggested that we just assign some reading materials and homework to the students and save the lectures to the date that we were able to provide face-to-face class. The second focus was whether we should provide recorded lectures or live lectures. The third was whether to rely on WeChat group or to try some other programs that we were not familiar with. To find the best way of online teaching, we carried out some tests and demo classes. After the discussions and tests, most of us decided to choose ThinkTalk and Tencent Meeting as the main teaching platforms. This also has become a very popular choice for other universities in China. And thus, ThinkTalk and Tencent Meeting, two programs originally designed as working platforms to support enterprises, played important and unexpected roles in supporting tens of millions of schools to provide online courses in this pandemic. The course Otto and I taught was International Water Law. This is an optional course open to all graduate students of CBOS. I teach the first 6 lectures in Chinese. It's a general introduction to international water law and about the transboundary water cooperation between China and its neighbors. It's followed by 6 more lectures in English offered by Otto. This was the 5th year that we jointly taught this class. We first did so in 2015. In the last 5 years, Otto traveled to Wuhan to teach the class every spring. 2020 was the first year that Otto decided to join CBOS as a full-time professor and happened to be the first time that we tried online teaching. During the lockdown, Otto was in Hague while I was in Wuhan. I live with my family in a complex with a population of about 3,000. There were 45 cumulative confirmed cases of COVID-19 in this complex. It used to be a very lively place with people walking, talking, and the children, kids having fun everywhere. But during lockdown, it became extremely quiet. Even the noisy children were kept inside, on the one hand to follow the suggestion of the government, on the other hand, for fear of the virus. In the most difficult time, we were not allowed to go outside the complex and had to rely on group purchases for food and daily necessities. Unfortunately, I did not have copies of my PowerPoint presentations at home, nor did I bring my reference books from my office before the lockdown. But thanks to this internet age, I found enough supporting materials online and developed new PowerPoints. All my 6 classes were conducted in the form of live lectures through DingTalk. I found it very challenging to give lectures to a screen without direct eye contact with the students. Although I was quite familiar with the teaching content, I felt quite nervous under such kind of circumstance. The students seemed also nervous when talking to the screen, so they were more reluctant to answer questions than in the face-to-face class. I made some adjustments in my last several classes, and gradually I got used to that form. But even after completion of all my 6 classes, I was not able to find a satisfactory way to solve all these problems. The last challenge was to keep my 2 boys quiet when I was teaching. The ways to consume their energy was too limited during the lockdown. Apart from DingTalk, we used the WeChat group as the way to communicate with the students. With the help of WeChat, I also communicated with my colleague Otto frequently before, during, and after the course. Now, please let me give the floor to Otto. He will go in more details of the teaching process and share his personal experiences teaching to students in China from a distant apartment in The Hague, Netherlands.
Yes, thank you very much, John. Yeah, one thing you notice immediately as soon as you enter China is how crucial WeChat is. Huh? So even when I was in The Hague, we were constantly communicating via WeChat. But when you're in China, you actually realize that basically everything is done via WeChat. But at the time I was teaching this course, I was still in my hometown in The Hague in the Netherlands. So I will first say a few words about how I prepared for the lectures and then how I delivered them, and then say something about the examinations. So how did I prepare? Well, I understood from John Van how difficult it was to give lengthy live lectures. So I decided to instead record short knowledge clips in a recording studio at Utrecht University. That is the university where I worked before I became a full-time professor at Wuhan. So they allowed me to make use of the recording facility. So I recorded 4 knowledge clips in advance and shared those with the students so that they could watch them at a time that was most convenient to them, and also multiple times if necessary, because some students may be a bit struggling with the English language. Not as much as I'm struggling with the Chinese language, but you get the point. So for the online meetings, I prepared short PowerPoint presentations to complement and not to repeat the knowledge clips that I had prepared. So these PowerPoint-based mini lectures, they dealt with issues such as the rights of the river and the examination of lots of watercourse specific agreements, and also the human rights approach to water law. So topics that were a bit off topic and that were not necessarily addressed in my knowledge clips. We also adapted the syllabus that we had been using for the course to the extraordinary situation. But the essence of the course was not really changed all that much. So compared with previous editions of our course, the main difference was the omission of the oral pleadings part of the assignment. And the assignment was done in the form of a moot court. I will say more about this later. Next slide, please. John, can you go to the next slide, please? Yes, thank you. So I taught my lectures from the 9th of April until the 14th of May of 2020. when the lockdown in Wuhan was actually already partially lifted. So our students were both master and PhD students of CBOS, that's the Center for International Boundaries and Ocean Studies at Wuhan University. But many of these students were actually auditing the course. So only 5 of them took it for a grade and took part in the moot court assignment, and the rest was auditing. At the beginning of each live meeting, I began with my mini lecture, and then the students all switched off their microphone and their video, which made it impossible for me to see how my lectures were actually received. And I found that very frustrating. So I was basically talking to an image of myself, and I could not really interact in any way with the students. So after my mini lecture, the students were urged to ask me questions. And when they did, I asked them to switch on their video, but many of the students, they didn't. They only switched on their microphone. I also shared some recently published papers and other materials with the students via this WeChat group that we have made. WeChat is the same as WhatsApp for the Americans among the audience, but then the Chinese version. I also used this same WeChat group to remind students of pending deadlines, so the submission of their draft memorial and the final version of their memorial. And I used WeChat to give feedback to any production that the students shared with me. So we tried to make the best of the situation, but I really missed the possibility to look the students in the eye and to continue our conversation during the breaks or after class, etc. And I also found it very difficult to get an idea of whether they actually appreciated my clips and my lectures. I found that very hard to get the sense of that. And I also remained ignorant of the circumstances the students found themselves in. So only months after the course had already actually ended, I understood that most students had left Wuhan by the time our course had started. So they were taking the course from within their family homes. So they had already left the city of Wuhan. Next slide, please. About the exam, so the examinations were organized in the shape of a moot court. And we actually based our moot court problem on an actual problem, and that is the construction by Ethiopia of the Grand Ethiopian Renaissance Dam in the Ethiopian part of the Nile. So we made it a controversy between Egypt and Ethiopia. And of course, Egypt is then claiming that the construction of this huge dam is in breach of the obligation of Ethiopia to use the Nile in a reasonable and equitable manner and not to cause significant harm to its neighbors, i.e. Egypt. And then of course, Ethiopia is supposed to deny all these claims. So we divided the students into 2 groups. One group had to prepare a memorial for the applicant, Egypt, and the other for the respondent, Ethiopia. So they could submit a draft and they could ask questions and then submit a final version with the help of the answers I gave to those questions. So in previous years, we had both a written stage, the writing of the memorials, and an oral stage, that's the delivery of the oral pleadings. But the latter part, the delivery of the oral pleadings, we decided to cancel because basically everybody was somewhere else and it was very hard to have a moot court in this way, which is really unfortunate because that was sort of the highlight of the course in previous years. So the students actually managed to coordinate their efforts quite well, considering that they were all located in different parts of China with family. So they were able to communicate via email, WeChat, and online meetings, and they did quite effectively. So to conclude, can you go to the last slide, please? I wanted to share some reflections on teaching regarding teaching as a priority in these extraordinary times. So Chang Fan already referred to some policy documents of the Chinese Ministry of Education, and then of Wuhan University, and then of the CBOS, the institute where we work. And all three were very determined from the beginning that teaching had to continue. The discussion was only about the way in which to do it, but none of those three actually ever considered to stop teaching. I find that very remarkable. So China has a long tradition of appreciating the value of education. So maybe it's not that surprising that teaching continued despite the extraordinary circumstance and even during the height of the Wuhan lockdown. But both students and professors agreed when we evaluated the course later that online teaching is really no replacement for the old style on-site physical teaching. And I'm happy to say that contrary to almost all of the rest of the world, in Wuhan, we actually do teach in the old-fashioned way already, again. So our experience only underlined the value of on-site teaching and its importance. And of course, if you refer to China and its tradition, you cannot avoid making a reference to Confucius. And Confucius already made this distinction between knowing things and learning things. This is an issue that also came up in the first lecture a couple of hours ago, that there's a difference between knowledge transfer and understanding or learning things. So knowledge clips can perhaps work very well to transfer that knowledge from the professor to the student, but without actual interaction, students do not really learn in the deeper sense of the term. They don't really understand the material. And knowing without learning leads to the dissipation of the mind, said Confucius. So it was thus, a rather unhappy experience in various ways. And I think it's good to be honest about this. But we were just trying to make the best of it. And yeah, perhaps the students are still too young to know that the heart's memory eliminates the bad and magnifies the good, and that thanks to this artifice, we manage to endure the burden of the past. That's actually a quote from Love in the Time of Cholera, this novel by Gabriel Garcia Marquez that we used to draw inspiration from. So let's hope the students will remember the good parts of our online teaching experiment and forget all about the rest. Thank you for your kind attention.
Thanks so much, Otto and Zhang Fen, for that very detailed account of your experiences, which I'm sure shared to some extent or another by a large number of the participants. And I also feel that we all long for the time that we can return to our classroom. It would mean, for instance, that I won't have to worry whether I've got my label back to front or something like that. I still haven't sorted things out with my Zoom, as you can see. So is it back to front or not? I don't know. Anyway, I thought, unfortunately, Chinmay Sharma could not be with us, but she has submitted her paper. And I thought this is a very interesting paper, so I thought I should read it, even if it is in a condensed version, because that would add to the richness of the conversation. So this is by Chinmay Sharma, who's on the visiting faculty at the National Law School of India University. So over the past several years, I have had a number of opportunities to learn and teach international law in various capacities. My perspectives on pedagogy in international law have been shaped acutely through these experiences, which have taken place both in India and in other countries. Key takeaways emerge from the contrasting experiences within India and outside of it, primarily Western and European contexts. Most notably, it is the level of engagement with trail perspectives and scholarship that stands out. As a student, I was introduced to 12 scholarship early on during my undergraduate public international law course in India. It was an area of much classroom debate and saw substantive engagement from students. Now, having taught international law at three of India's leading universities, I see the same degree of engagement with 12. Students are keen to critically examine and question Eurocentrism in international lawmaking and the histories of international law. There are substantive discussions on the normative value and legitimacy of international law in light of its Eurocentric origins. Students have also been keen to produce research in these areas and have also asked to engage with 12 perspectives, where it has not been strictly been part of the course syllabus. Oh, that's encouraging and interesting. In contrast, the same level of engagement with 12 perspectives was not observed in my experiences of studying international law in the United States, the United Kingdom, and Europe. Eurocentrism did not form such central points of discussion and did not receive as much scrutiny as within the Indian classroom. There was also a distinction in the level of incorporation of 12 scholarship in syllabi. In my view, the status of India as a third world or developing nation, coupled with our colonial past, plays a significant role on the manner in which international law is taught, examined, and internalized here. It appears to be almost natural and instinctive for both teachers and students to engage with 12 in international law courses. It is a perspective that simply cannot be omitted. As a consequence, it plays a key role in conditioning how students view, understand, and evaluate the international legal order. This may not be, and from my particular experiences, does not necessarily seem to be the case in Western or European classrooms. This contrast is certainly something that needs closer examination in international law pedagogy. And aside from the pertinent question of 2-year scholarship, the onslaught of the COVID-19 pandemic has also had an impact on the teaching of my international law course. Upon student request, classroom discussions were held examining responsibility and remedies in international law. In these discussions, a critique of different kind of power differential emerged strongly, that existing with the UN Security Council and relating to the permanent members. It is highly likely that in the aftermath of this pandemic, there will be further scrutiny of power structures in the creation and enforcement of international law, particularly in the classrooms of countries like India, where students are already attuned to critically questioning these themes. So that was Chinmay's paper, at least a condensed version of her paper, which raises a number of interesting points about, well, what decolonization would mean in a different context, for instance. So those were the presentations we've had the benefit of hearing. I see we already have a number of questions here on the screen. So perhaps I can begin. I think a few of them, actually, the first question from Eric Scarf, I think applies to certainly to you, Jenny, but also perhaps Otto and Zanfen, you might have some comment about this question, about the extent to which some of these problems in teaching international law relate to an obsession with the connection between law and enforcement. If students and perhaps the public more generally were to come to understand that the existence of international law and enforcement of law can come apart, would this open up more space for a broader conversation about private and public international law? So it's an interesting question. It's a standard concern that international law is pointless because it can't be enforced. So that seems to be very much a criticism of international law. But I wonder, Jenny, in your experience, whether that is the main criticism of international law or the main concern about international law.
Yes, I think that is definitely part of the concern. For example, here in Myanmar, what if these bodies, for example, the ICJ proceedings, what if, what can the ICJ proceeding do for in terms of reforming the 1982 citizenship law in Myanmar, which um, is one of the thorny issues concerning ethnic minorities in the country. How far can an ICJ decision go in terms of um, in terms of changing the legal system or shaping the legal system. But I think the value of international law is, I think, at least from what I see in practice, is less about enforcement, but all as much as how international law affects the legal culture of the country and how certain doctrines or ideas about international law resonate with the public. So, for example, Myanmar has not ratified treaties like the ICCPR, which guarantees civil and political rights, but we still use them, at least in my NGO, as a hook, and to try to find a way to improve the legal system as a through these treaties. So I guess the value is also in the concepts and how these concepts can shape the legal system of a country.
Sure. So Otto and Zhangfen, you didn't particularly address this issue, but would you have any comment about how international law is viewed generally by your students in China? Is it seen as as effective or not effective as national law? Are there any concerns about what is the point of studying all this when we have an arbitration decision or something like that, but it has no enforcement value? Do you encounter that problem?
Well, yeah, I only have limited experience teaching in China, of course, but what I notice is that Chinese students are very well aware that international law can have a huge influence on the way a debate or controversy is framed. So a particular decision, an arbitral award, for example, can have a huge impact on the way people look at a certain controversy. And my experience is that Chinese students are very well aware of the influence international law can have in this way. So that's not about enforcement at all, but more about how debates are shaped.
Very interesting point. And of course, one can see how the South China Sea features in those particular understandings, as it were. Zhangfen, would you have any comment?
I think as one part of the Asian countries, China share many similar things, as told by my colleague just now. For example, in China, international law is not considered as the mainstream subjects within all the areas of laws. One important reason is that international law is deemed as law not enforceable. I think that's one important reason. So people may think that international law is not so important, and also international criminal law is not mainstream of public international law. So we share some similar things on these points. But I think these years I found people pay more attention to international law in China. Many issues are become related with international law, such as South China Sea issue and also something related with the COVID-19. No matter how people look at these issues, people become to think about these issues from the perspective of international law. So I think the importance of international law has been increasing significantly these years in China. Yeah,
thanks very much. Very interesting observations. So international law is important and effective because, as Otto says, it shapes the particular vision, the particular structure of thinking about a particular issue in that regard. A few other questions. There are several questions about why Asian students may not be especially engaged with international law. It has to do with this issue of careers in international law and whether one can change the incentives. Because it's something I've encountered also in my various in visiting various Asian countries. I find myself being asked by by my host, I've been asked, well, could you please convince them that international law is important because they don't see themselves as wanting to do international law. But in Asia, the paradox is that in many Asian countries, international law is compulsory. So that's something that we found in our survey, that in quite a large number of countries, international law is a compulsory subject. And so it seems to suggest that at that time, when some of the Asian universities were beginning, they felt that part of their mission was to understand the role of these states as they were emerging, understand their role in the world, and international law was very important for that. But I suppose there is this question, I think Jenny, you raised this as well, what can be done in terms of incentive structures to make international law a profession, a viable profession. And I guess you can reflect on your own experience, coming from the Philippines. What made you study international law? What made you think you could have a career in international law? What led you to this peculiar delusion that it was, worth pursuing as a vocation?
Yeah, I think delusion is the right description, Professor. So I agree with
Tony,
you. Tony, okay. So I believe that as a student, you're right. There are indeed opportunities like moot court, JESUP, IHL, moot court competitions, research opportunities as a student. But then it changes. I was one of those students, but then it changes once you graduate from law school and enter the profession. There's mainly the corporate law firm to go into. And I think part of that is a lack of opportunity, and I'll go into that later. But another part is that the profession is has mostly corporate lawyers. So if you see one kind of lawyer everywhere, then the options that you're not going to even explore or inquire about other options because people around you, surrounding you, people you look up to, lawyers you look up to, all go into corporate law practice. And to answer your question, I think what schools can do, at least in the Philippines, is really to look for funding opportunities for these students to do unpaid internships in international institutions. Now, in the first place, there should not even be an unpaid internship because that already is an unfair system. But second, given that this is the reality, and while we're waiting for the system to change, law schools should at least look for funding sources for students who are interested in international law. For those mooters and for those JESUP participants, there should be an opportunity for them. And just to share with you my own experience, I was one of those people, I was already a corporate lawyer, and I decided to sell my car to do an unpaid internship at the ICC. And good thing I have a car to sell. Not many Filipinos have my privilege. And you see the level of sacrifice that a person from the Philippines has to do. And I'm sure this applies even more for Myanmar. The level of sacrifice that you have to do an unpaid internship without practical returns. And so you really really have to want international law to be able to do this. So I think looking for funding sources for schools, that is a very concrete thing that they should do. Collaborations among universities, and here I share what my other what the other panelists have already discussed. Collaborations among universities, especially now during COVID, because everything is online, there's actually more opportunity to talk to one another from different countries about international law. And that includes conferences like this one, and also in the region, in Southeast Asia. And I think that should be a good starting point. I'll end there.
Sure. So this question also applies. What career opportunities do your Chinese students have? How do they perceive their training in international law as leading to a career? Or
I think
something. Or do they take international law incidentally? It's just another subject, but they don't regard it as a career pathway?
I think it's easier for the Chinese students to get funding to intern at the international organizations. That's not a big problem for Chinese students. The government and the universities, they are willing to support them to intern at the international organizations. But as Jenny mentioned, for the students who do not have English as the native language, the fluency of language is a big problem. So it's not so easy for Chinese students to get internship in those international organizations. Another problem is that the international lawyers as a profession is not a profession that can have many people. Only the top students, only the top lawyers can have a place in that profession. So it's not like the corporate lawyers. So the corporate lawyers, they can start from young people. They can incorporate many graduates, young graduates. But for international lawyers, I don't think there are many international lawyers, maybe no real international lawyers in China. So when Chinese government want to look for some very good Chinese international lawyers to find some answer to the international law questions, it's very difficult. It's really difficult. So I think that's a problem that the Chinese universities and also the Chinese government want to solve. They want to develop the career. They want to develop the profession to make a very good group of international lawyers, but not so important. It needs long years. But for the young graduates, they thought that's so difficult to get into the profession to become top lawyers. I'm not sure whether I have made myself clear. So that's my observation on this point.
Well, you make a number of interesting observations. One, and this thought was also prompted by one of the questions about even if Asian students can become international lawyers, they do become international lawyers by following a fairly conventional pathway, and that is, operating within the structures themselves. And I do sense that in some Asian countries, there's quite a demand for international arbitration. There's a huge interest in international arbitration, in investment arbitration, partly because that combines international law with the commercial. And of course, if you're fortunate enough to eventually become one of these major figures in the world of international arbitration, this is a very rewarding career. But it is extremely difficult frankly, for Asians to, if we have a look at the prominent international arbitrators in investment arbitration, for instance, it's very difficult to think of many Asians who are part of the international investment arbitration system. Maybe Michael Huang, for instance. But Zhangfan, you raise a very interesting question, because another feature we see in many Asian countries is that whenever there's some kind of an international dispute, Asian countries don't rely on their own lawyers.
Yeah.
They will go, and this could still apply to China, a country as powerful as China. They will go to Oxford and Cambridge, and so it's fascinating to see that there's still a massive dependence upon a particular set of lawyers located in Europe, usually, or perhaps in Boston. And they are the people who argue the major cases. I can't remember who appeared for the Philippines in the South China Sea case, but it's very interesting. A dispute between Foley Holmes. Okay. So a dispute between Malaysia and Singapore results in a situation where, of course, you could say the nationals from those countries do appear as part of the team, but the major arguments are made by professors from elsewhere. And the bar at the World Court is a very closed bar. It's a very limited bar. So it's completely understandable that international, Asian students feel that there isn't really much of an opportunity. It's a large struggle to get to these particular places. So I think some of the questions raise those interesting issues. Um, uh, Jenny, there's a specific question about the Philippines, a rather lengthy
Tony,
question.
can I, sorry,
Sure,
I just remembered something. Can I add one
sure,
last thing? I
of
think
course.
one another thing we should consider is the people who hire in these institutions and their markers of excellence.
Hmm,
So if whichever country they come from, but if they're in their estimation, what's excellent is these Ivy League institutions or Oxbridge, then that would also narrow the opportunities for people from Asia. So there, I just want to.
sure. And it's funny. If we think of the situation, and frankly, just a personal anecdote here. My teacher and mentor was Judge Veeramanthri, the Sri Lankan judge, who was on the ICJ. And as ICJ judge, he said he found it very frustrating because he said there are arguments that should have been made, but which were not made. In other words, people who come from a different background uh, would have made a different set of arguments. But it seems that it is a particular set of people who have a particular training and a particular mindset who are chosen and who proceed to make those arguments, which can be somewhat limited in that way. So those are some sort of further perhaps questions to think about in this regard about how this could all change. Jenny, there's a detailed question about the Philippines, uh, basically saying, well, neither international law nor national law is particularly followed in the Philippines. So that's a rather dim view of what is happening in the Philippines. Um, and, um, and how the law can be made accessible to the people because of the fact that uh, the laws, again, it's a different type of exclusion. We'll be talking about Eurocentrism as being a type of exclusion. But here it seems that even within the Philippines, the laws are in English and cannot be easily understood by the majority of the population. So that's another set of complications. Would you just care to say a few? It's a very complex topic. I don't expect a comprehensive answer, but would you just care to say a few things?
Yeah, I agree. So the official language in the Philippines is English and Filipino, but court proceedings, government documents are all in English. And so I actually agree with the suggestion of the attendee that let's translate some of these documents into Filipino so that more people will understand. And I think that has contributed to the polarized political climate in the Philippines.
I just had a sort of personal observation in terms of your very interesting presentation. You know, the the few international lawyers who might be found in Myanmar or well, Philippines, of course, has a very distinguished tradition of international lawyers. And I should also mention that one thing that has really struck me is the fact that we don't really know very much about Yutan. Talking about Myanmar. So I have, we held Trila Myanmar. We held a Trila workshop in Myanmar, and as part of my attempt to, you could say, make local history relevant, I started doing some sort of inquiries into Yutan. Now, he doesn't have the major profile, of course, that Hammarskjöld would have or Kofi Annan would have, but I think he was a fascinating Secretary General. He was a Buddhist. He did not want to be Secretary General. He was the Secretary General at the time of the Cuban Missile Crisis. But he didn't want to play a sort of dramatic, flamboyant role. And I couldn't find a biography of Yutan. But the odd thing was, it was, I felt I was, and it felt very awkward where I was telling people from Myanmar about Yutan.
So one of the last
So,
things I did before COVID happened. Oh, sorry.
yeah,
Did
go
I
on.
cut?
Mhm.
So one of the last things I did before COVID happened was to visit the Utant House. So it's a museum that was set up by his grandson, the famous
Yeah.
historian Tant Min U. And I would actually recommend Tant Min U's books on Myanmar because they present a nuanced account of the country's history. And I think this is also one other thing that we can do as lawyers in Asia or people interested in the study of Asia is that we read more about each other's countries. I know many Filipinos who don't know anything about Myanmar. I know a lot of people from Myanmar who don't know anything about the Philippines. And I think that is part of the problem because we talk a lot about ASEAN. ASEAN, what ASEAN thinks and does bears on Myanmar politics and Philippine politics, but the people don't know about each other's histories.
And that's sad because, if you look at Bandung, another one of the great moments in the history of not just Asian international law, but I would say international law. One of the ambitions of Bandung, and it's found in the communique, is that we should develop a great understanding of each other's cultures rather than look to the West all the time. But it seems that this has not quite happened. And it's an interesting question. Even if we're talking about discussing the issue about teaching international law, uh, Barry mentioned the symposium that Trila and Afronomics hosted. And we were my colleagues at Afronomics were especially inspiring this regard. We wanted to create a discussion among countries of the South and what they could learn from each other, rather than continuously use, Europe or the United States as a sort of reference point as to what needs to be done. The other thing I find very um, uh, uh, a source of great challenge to many young scholars in Asian law schools is that this whole question of rankings is playing havoc with law schools. I don't know how you experience it in China. I just got an inquiry from a colleague from China saying, what is your tenure process? Because there is the sense that in order to rise in the rankings, we need to mimic the tenure processes of, the Ivy League schools or Oxbridge or something like that. And I found in places like Myanmar and Indonesia that young scholars are placed under huge pressure to publish because suddenly they are being given targets about publishing in international journals and so forth. And I'm trying to understand where all this is coming from. And so I think there's a whole kind of infrastructure of neoliberal education in place, which is infiltrating, I think, infiltrating in a different way. It's already infiltrated all, institutions in the UK and everywhere else, I think. But it's infiltrating in a different way Asian law schools. And it's creating, this obsession about rankings and rising in the rankings and what needs to be done for that. And as far as I'm concerned, because of my interest in the history of international law, this is something like a new standard of civilization. We've got to meet this standard. Rankings are you could say, the new system that needs compliance. Anyway, these are just some asides. But Jenny, the specific question I had was, your presentation is also very relevant to a country like Sri Lanka, which is still, not addressing all the issues that remain after the civil war. And the problem is, the problem I encounter is people saying, well, look at what happened in Iraq. There's no action against Tony Blair. These people are arguably war criminals. Nothing is being done. And I think Tony Blair earns a good $10 million, 10 million pounds, 20 million pounds a year as a consultant for various entities. And so the complication here is that Asian countries could learn the wrong lesson from what happens in the West. I mean, I think in the United States just now, military contractors who were found guilty were pardoned, right? In the United Kingdom, you have a massive inquiry into the Iraq War, the Chilcot inquiry, but it's made clear right from the outset that no one is going to be held responsible in any meaningful way. And then we have the recent, my friends who are international criminal law, you could say, experts, had great hopes for the Afghanistan inquiry and so forth. And so I don't know quite how to respond. I don't know what to say and so lawyers can be quite focused in pointing out all these discrepancies. And the further argument they make is to say these people invaded another country. So they make a distinction between violence within the country, which is seen something like, oh, it's a family affair. It's within our domestic jurisdiction. And somehow there's a different mindset for that as compared to invading another country, which is seen as much more odious, much more, well, that's a war of aggression. Any thoughts? So in other words, your presentation focused on the internal drivers. But my suggestion is that you can't consider the internal drivers without considering also the external drivers.
Yes, and I think that's where NGOs should also be equally vocal in calling out the double standard and in calling out what these countries are doing. And I think the lack of attention that NGOs put into these issues also creates an impression among people in places like Myanmar and the Philippines that there is a double standard. And but then you have the issue of donor funding in NGOs, which is another which merits a separate panel discussion. But I think that that's the system, right? It's about changing the system. But I think that one way that we should equally call out countries like the US and what they're doing, for example, to undermine the work of the ICC, or in banning. Well, now it was overturned, thanks to Open Society. But before that, banning the ICC prosecutor from entering the United States. So I think we should call out these NGOs should do their part as well, in the limited space that they can, given that there are constraints uh, uh, due to donor funding.
Sure. Well, the 12 point would be that, the fact that the violence is being inflicted by your own state doesn't make it any more legitimate. So I think that would be a sort of 12 approach to this. The fact that, imperialism is bad, but sort of nationalist violence is really no better in these types of circumstances. So that would be one way of trying to respond.
I actually hear this refrain a lot in the Philippines to support the drug war. So they're saying, but the US is bad. It colonized the Philippines. But yeah, but that doesn't speak about the current violence that is happening in the country.
Sure. We had a few questions. Okay, so wow, we got a few more questions about issues. So one interesting question is about the teaching of international law. And it was raised actually in the 1964 report as well, the language of teaching international law and the complications about this. So in China, of course, it's taught in Chinese and English. But is there any sense of, well, at some stage, one has to learn a European language in order to climb the ladder of international law? You don't have to answer that, Jean-Pierre. Okay, I just wondered, Barry, Jean-Pierre, any comments or thoughts at this stage, because we're close to the end?
No, I think it's been a really fruitful discussion. It's been fascinating insight into a lot of the issues that are confronted in the Asian context in particular. I do find this idea of, I do think there is just a number of different themes. So, if we look at the situation when the pandemic began, and the expectation that the show must go on and all the pressures that come from that also relates to, I think, this neoliberal model of education where, you're providing a service to some extent. And there were a lot of pressures, and there still are a lot of pressures that are placed on academics. And this is not unique to, I think this is in a lot of different contexts, regardless of the realities that we're experiencing. And then, so that's one theme that occurred to me listening to the presentation about online education. But yeah, and then the other theme that really spoke to me was the idea of the relevance of international law. And I actually think that it's interesting because this is a topic of conversation that I think actually comes up again and again around the world. Maybe, I mean, obviously with particular distinctions based on context, but it does seem to be a perennial question for the international lawyer to kind of justify their existence, and then also to justify the existence of the subject in the curriculum, maybe in different contexts. And I do think that the social exclusion that persists in the career side of this field is to some extent a large part of that. It's incredible that a field that is premised to a large degree in rhetoric, in doing justice, can be so socially exclusionary in so many ways. And it just kind of persists. You know, you hear the narrative again and again, we're all kind of waiting for the system to change, but it never really does. So I do think that this is a huge challenge for the field, for those of us who are engaged in the field at the moment. There seems to be a consciousness of, you know, a lot of systemic problems, the neoliberalization of education, the social exclusion in the career side, the ongoing, you know, domination of certain knowledge structures, and this came up in the first webinar. But I guess what's missing are, to some extent, are, you know, sort of concrete strategies for change. Yeah, I guess maybe that's my lament, but those are my thoughts.
Well, Barry, I would like to think that your subsequent webinars will address all those issues and hopefully come up with some solutions. So we're fortunate to get in early. Jean-Pierre, any closing thoughts or comments?
No, I think the issue of social exclusion that Barry just mentioned is the one that I was going to talk to a bit. But the other point, I guess, and it's something that's come up in the comments by Guillermo and others in the questions, is this idea of some of the issues that are being discussed in the Asian context can also be applied to other contexts. So the Latin American context, for example, or the African context, as we heard in the earlier panel. And I think those kind of similarities will be interesting to kind of discuss over the course of the next few months. So thank you very much, everyone, for your presentations and discussion.
Great. So thanks so much, everybody, for the wide range of issues discussed, all the way from, you know, the practical issues of teaching in the pandemic to these larger questions about social exclusion and change. And I think the next event will be in 2 weeks' time.
3 weeks.
I think it's 3 weeks.
3 weeks' time. Okay. So we look forward to that event for a further exploration of these complex topics. Thank you very much, everybody. And from my point of view, good night.
and just I would just like to say thank you so much, Tony, especially for delivering an off-the-cuff presentation in light of the difficult circumstances that some of the other panelists experienced. This is, you know, as everyone knows, this is a unique time that we're in, and difficulties do arise for many of us. But we're very privileged and fortunate that you were able to step in with some of your own experiences. So thank you so much, and thank you to all the panelists for wonderful presentations. I really thoroughly enjoyed them. And thank you to all the participants for engaging in the discussion and all your questions. We look forward, hopefully, to seeing many of you again in 3 weeks' time, where the topics will be the tools and techniques in teaching international law, and a special panel organized by the International Committee of the Red Cross, Teaching IHL in Crisis, a Strategic Response for Troubled Times. So yeah, thank you so much.